Hi, welcome back. In this session, we are going to discuss about closure under Industrial Dispute Act of 1947. Section 2, subclause CC defines closure. It means the permanent closing down of the place of employment or a part thereof. In the definition, the reasons for closure is not stated. Notice of closure must be made. The employer must give notice of closure to the appropriate government. The following are the requirements of a closure. 1. It must be 60 days notice. 2. It must be in the prescribed form. 3. It should state clearly the reasons for the intended closure of the undertaking. The right to close down is fundamental right under Article 19, subclause 1, subclause G. This was so ruled in Hathi Singh Manufacturing Company Limited versus Union of India. So it was in Hathi Singh Manufacturing Company Limited versus Union of India that the Supreme Court held that the close down is also a fundamental right under Article 19, subclause 1, subclause G of Indian Constitution. Now, in A1 Services Production Agencies versus Industrial Tribunal, the Supreme Court ruled that closure of an undertaking means closure of a separate and distinct business. In Excel Bear case, the Supreme Court ruled that an employer has the fundamental right to close the business at any time. Now, exemption from notice. According to proviso of Section 25 FFA, the notice provision is not required for an undertaking where less than 50 workers are employed. An exception order from the government is necessary. Now, the government will specify the period of time in which the exemption benefit is available. Now, in SG Chemicals and Dyes Trading Employees Union versus Management 1986, in SG Chemicals and Dyes Trading Employees Union versus Management 1986, the court had pointed out that there were more than one undertaking constituted a single industrial establishment and employed a total of not less than 100 workmen. The closure of one of them, if having less than 100 workmen, would attract only Section 25 and not Section 25FF. So here, in SG Chemicals and Dyes Trading Employees Union versus Management, the court pointed out that where more than one undertaking constituted a single industrial establishment and employed a total of not less than 100 workmen, the closure of one of them, that is, there are several undertakings, the closure of one of them, which is having less than 100 workmen, would attract only Section 25 and not Section 25FF, even though it is under one industrial establishment. Now, that was held in SG Chemicals and Dyes Trading Employees Union versus Management 1986. The court in Johnny versus Coir Yarn Textiles 1960, had observed that events like natural calamities beyond the control of employer are included within the ambit of the phrase unavoidable circumstances under Section 25 FFA Clause 2. In Radio Electrical Limited Madras versus Industrial Tribunal Madras 1970, in Radio Electrical Limited Madras versus Industrial Tribunal Madras 1970, the Madras High Court pointed out that closure of even a section of an undertaking will attract the provision of Section 25FF. It is mandatory on the part of the employer to pay compensation when there is closure. According to Section 25FFF, that is FFF, Section 25FFF, such an employee must have completed more than 1 year of continuous service. The compensation to be paid must be calculated on the basis of 3 months' salary drawn just before the date of closure. The court in the following cases had considered the scope of the problem of closure. The first one is Hathi Singh Manufacturing Company versus Union of India. Hathi Singh Manufacturing Company versus Union of India 1960. The court said that it is immaterial to consider the motive of the employer to decide whether the closure is bona fide or not. Now, the second case, that is in Pipraich Sugar Mills Mazdoor versus Pipraich Sugar Mills 1957. In Pipraich Sugar Mills Mazdoor versus Piperite sugar mills. Here the court held that where the business has been closed down and it is admitted and found that the closure is real, the employees are entitled to compensation. Now another case law, that is the third one, that is Indian Express Newspaper Limited versus their workers 1982. Indian Express Newspaper Limited versus their workers 1982. Here the court observed that if the action taken by the employer to close down be bona fide, any dispute arising cannot be treated as an industrial dispute. So that was held in Indian Express Newspaper Limited versus their workers 1982. Then we have another case law, the fourth one, that is Kalinga Tubes Limited versus their workman 1982. Kalinga Tubes Limited versus their workman 1982. The court said the court cannot analyze the motive of the employer. Now another case law, that is the fifth one, in Tata Oil Mill versus their workman 1980. That is by decision by Kerala High Court. So here the court observed that where the fact of closure is admitted, a tribunal shall not go into the question of the motive of the management. And the final case law with respect to the closure, which discuss about the scope of the problem of closure, is Parry Company Limited versus PC Pol, that is in 1970. Parry Company Limited versus PC Pol 1970. Here the court emphasized that it is the right of the management to close down the factory. So that is decided in Parry Company Limited versus PC Pol 1970. So these are the 6 case laws which can give us an idea about the scope of the problem of closure. Now closure and retrenchment. In the case of closure, the business is closed or permanently discontinued, but in retrenchment it is not closed. Notice and compensation are condition precedent for retrenchment, unlike in closure. For retrenchment is conditions precedent and in closure it is not. So in retrenchment, first come last go rule is applicable, unlike in closure. Now closure and lockout. In case of closure, the employer is not only choosing the place of business but also closing the business itself, whereas in lockout either the place of business is closed or the work is suspended or the employment is refused to a number of persons. Now in lockout it is resorted by the employer as a retaining measure, whereas in closure this element is absent. In lockout the employer and employee relationship is subsisting, whereas it is terminated in closure. So that is with closure under Industrial Dispute Act. Thank you for listening. Like, comment and subscribe. Click that bell icon so that you get an update when I upload my next video or an podcast. Thank you for your support.